Hi, I'm Joel Reedy, a founding partner at Cornerstone Law Firm. Today I want to answer a common question relating to the coronavirus crisis and the shutdown that's resulted, which is how does the Family Medical Leave Act protect employees during this time, and what do employers have to offer their employees in regards to the shutdown? So, first of all, the Family Medical Leave Act is a federal statute that applies to public sector employees, that is, employees of government entities, and to private sector employers who employ more than 50 individuals at a location. So this applies to large and medium businesses as well as government agencies. It requires that the employer give employees 12 weeks of unpaid leave for medical emergencies in a 12-month calendar period. So whether it starts in October, for example, and goes to the next October, or starts from the beginning of the year to the end, whenever somebody's using that leave within any 12-month period, they can have up to 12 weeks of unpaid time off. And this is for medical emergencies that are either personal, that is, that keep that individual from doing the functions of their job, or which they need to care for a spouse, a child, or a parent as a result of an illness of one of those individuals. This can cover childbirth. It can cover a lot of other scenarios as well. It can require an employer to give leave for mental health issues as well. Now, the real big question everybody's asking is how does coronavirus apply to all this, and what happens there? Do employers have to give leave for that? Well, the short answer is certainly if someone comes down with the virus, they have to be given leave if they're in a covered employer to be able to take care of themselves or a family member who is sick. But additionally, the bigger question is, do employees who have to take time off because of a closure due to coronavirus, do they get FMLA leave? This is kind of an unresolved question, and it remains to be seen. At the moment, there's not necessarily any court that's been called upon to answer this. Obviously, it's still early, but it's something that employers should be creating policies for at this point, and that employees should discuss with their employers to find out what rights they have. During their time on leave, the employees are not entitled to pay under the FMLA. Employers are allowed to require that an employee first use their paid time off or other vacation time before they begin taking FMLA leave. In addition, the employer has to provide whatever health benefits they're offering to employees has to continue during the FMLA time. So this video isn't meant to be legal advice, but my hope is that answers some of your immediate questions and helps you to kind of get a handle on FMLA questions. If you're a business owner or you're an employee and you have questions about how this applies to you and your situation, give us a call at Cornerstone Law Firm, and we'll be happy to help you figure out answers to those questions.